my dear colleague, Professor Bismi Gopalakrishnan, for the nice, very nice words. And it is very, very happy and very much encouraging to hear such wonderful words, particularly from a colleague. And at the outset itself, I congratulate Professor Bismi Gopalakrishnan for this wonderful academic initiative, and which is very much relevant in the current scenario. And she has taken all the efforts to choose the very learned resource persons in the relevant area. And such a wonderful, such a remarkable event. I congratulate you, dear Professor Bismi. And coming to the topic today, so we are discussing, or we are assembled here to discuss the very relevant topic on criminal law reforms. And let me share the screen. Wait for a few minutes, please.
Sure, ma'am.
Is the screen visible?
Yes, ma'am.
Is it visible?
Yes.
Yes, ma'am.
Okay. So I am straight away entering into the topic for discussion. We all are aware that the government has introduced 3 bills which touch the very essence of the administration of criminal justice system in India. The Bharatiya Nyaya Samhita, replacing our existing Indian Penal Code, Bharatiya Nagarika Suraksha Sanhita, replacing our Code of Criminal Procedure, and Bharatiya Sakshya Bill, replacing our Evidence Act. Now the bills are under discussion and is referred to the Standing Committee on Home Affairs. And it is the correct time for us to discuss how much is it relevant and what all are the changes that would brought about to the administration of criminal justice system. And I would like to bring your attention to the statement made by Professor G.S. Bajpai, who is the convener and member of the Committee on Reforms in Criminal Laws of 2020. He had identified the statement made by Lord Macaulay while introducing the present Indian Penal Code. The purpose for the Indian Penal Code was to bring uniformity and also diversity when it is required, but above all, the act meant to bring certainty. That was the idea proposed by Lord Macaulay while introducing the existing Indian Penal Code. And after over a century and a half of its operation, when the new bills, which touches the substantive law as well as the procedural law, as pointed out by Professor Bajpai, we are still faced with the erstwhile problems along with a multiple recent modern issues. Inconsistencies, inefficiencies, arbitrariness, unfairness, everything is still existing according to him. And the very aim or purpose behind the introduction of new bills is to remove all these difficulties. Let us see, or let us discuss to what extent the proposed bills can manage with these issues. Before going to the provisions and the content of these three pieces of legislations, we should have a basic or fundamental idea regarding the existing criminal justice system. I think majority of you are from law departments or having legal background. And even I think those persons from other disciplines also can understand the very basics of criminal justice administration, system of administration of criminal justice, because it touches all the spheres of our life, all the works of our life, and the day-to-day affairs in the life of every citizen. We know the purpose of criminal justice administration. It is to maintain law and order in the society.
Very good.
The very aim is to deliver justice for all. Justice means impartial, fair, equitable justice for all. And the system ensures to regulate the behavior of the people. It concentrates on regulating the conduct of criminals particularly, so that the occurrence of crimes may be prevented. And definitely punishment is the major part of criminal justice system. We know the purpose of punishments. It is to deter criminals, not only criminals, but also all the individuals, so that crimes may not be repeated in future. Along with it, rehabilitation of the victims and also the rehabilitation of the criminals are intended by administering punishments. Above all, the innocent members of the society should be protected. So the focus of the system of administration of criminal justice is to protect the society, the individuals, the accused, and definitely the victims. In other words, we can say that the major stakeholders are the society, victims, accused, and again the functionaries in the system of administration of criminal justice should also be taken into account. Let's begin with the analysis of the evolution of criminal justice system in India, because, or in any legal system, because only if we have started from the beginning stage, we can see to what extent changes should be brought about. Only if we are able to identify the development of the criminal legal system gradually, we can contribute to, positively, effectively contribute to the needs which should be addressed by redrafting or remodeling the existing system. So we know the history of mankind. When the number of people are very less in the society, there is no need of the state to interfere with administration of criminal justice. It could be managed between individuals, or private law remedies were sufficient. Individuals were permitted to take revenge upon the wrongdoers, and when the territory expanded and the society is expanded, the conflict of interest should be handled. The state felt that it should be handled in an effective manner. And it is not fair to leave the matter in the hands of individuals. Strict punishments based on the theory of eye for an eye, body for a body, that couldn't survive for a long period of time. So the governments felt that it is not good to leave the matter of taking revenge into the hands of individuals. So gradually, the state stepped into the shoes of the victims and started taking revenge upon the wrongdoer. If we are tracing out the development of common law, we can see the period of Anglo-Saxon reign, where we can identify the bifurcation of private law and public law, wherein the remedies for criminal acts or the punishments for offenses were handled by the state and not by individuals. So thus, the system of criminal justice emerged, and it became the duty of the state to deal with the wrongdoers and to deal with the commission of the offenses by discharging the primordial responsibility of ensuring justice in the society. And in that process, we can identify two systems of administration of criminal justice, that is adversarial and inquisitorial. I think you know that, or you have noticed that ours is adversarial system. And let us see the difference between adversarial and inquisitorial system, or let us have a comparison. In adversarial system, two parties, on one hand the state and on the other hand the accused. The counsels for both the parties, they present evidence before the fact. Witnesses were examined and cross-examined, and the judge, who is an impartial officer, he decides whether the accused has committed the offense. But in an inquisitorial system, the truth is tried to be extracted by way of investigation and inquiry. Both are done by the judge himself. So in the adversarial system, judge does not interfere with investigation that is done by executive or police or investigation mechanism, and he decides the guilt of the accused, decides upon the guilt of the accused based on the evidence brought before him. It is said that is the advantage of the adversarial system. We belong to adversarial system, and then again in adversarial system precedents, the earlier practices which have been appreciated by decided cases or the judicial pronouncements are followed. But in inquisitorial system, there is no relevance or scope for precedents. Then regarding investigation also, in inquisitorial system, investigation and judgment both are done by the judge himself, or he can delegate the duty to certain officials of the government. The peculiar difference is regarding trial. In adversarial system, as I have mentioned earlier, there are two parties, the state and the accused. In an inquisitorial system, the state is represented by a public prosecutor and the accused by his defense lawyer. There is no cross-examination or re-examination. See, the witnesses would be interrogated. The witnesses are identified by the judge and will be interrogated by him, though the witnesses may represent the parties. Then in evidence, collecting evidence, producing evidence, both these systems differ. Another important difference, crucial difference, is regarding the role of victim. That may be appreciated. The role of the victims or the scope of the victims in an inquisitorial system may be appreciated, because the victim himself can file a case and he is a party to the trial. But in adversarial system, in our system, the state only takes the cognizance and the victim is not a party to a case. So in that aspect, the role of victim is well appreciated in inquisitorial system. Adversarial system provides a very good hierarchy of thoughts in inquisitorial system, but at the same time, there are special courts to deal with different matters. The most important aspect is regarding presumption of innocence. In our system or adversarial system, the accused will be considered innocent unless and until his guilt is proved beyond doubt. But in inquisitorial system, there is no such presumption. When a charge is framed against the accused, he will be considered as the offender. He is the suspect, he is the offender. And the judge proceeds as if he has committed the offense, and the other thing should be proved, the reversal should be proved, that he has not committed. And coming to India so close, we have the background of common law, which we have followed from the English common law system. And we have statutes, definitely. The legal principles, the common law principles have been codified. And we follow we appreciate, our system appreciates judicial pronouncements, precedents. And the traditional laws under Islam and Hindu religions have its own role in our legal system. The religious morality, social ethics, etc. have been absorbed into our legal system. We can see the definition regarding various offenses in the penal code, wherein the principles of religious morality is well enshrined. And we know the history of the enactment of penal code, TRPC. And the question regarding the importance of common law that could be identified in the legal maxim lex, the importance, the relevance of lex non scripta, that is, we have to give acknowledgement or appreciation to the principles of law which are not in scripts. The unwritten code, the unwritten law, which flows through the ethos of the land, may be derived out of the morality of the society. Common law, or even the traditional principles of ancient Indian culture and legal system, gave much weight to lex non scripta. And the general part deals with the principles and doctrines, principles of legality, concept of wrong, punishment, responsibility, etc. Then the special part of the legal system, criminal legal system, that touches definition of crimes, specific crimes and prescribed punishments, And crimes are classified based on the harm they caused upon the individual's family, property, social morality, etc., etc. And inherently evil conduct, mala in se, and merely illegal behavior, mala prohibited. That means mala in se classifies the offenses which are inherently evil, like murder, theft, defamation, etc. But mala prohibita doesn't look into the aspect of inherently evil nature. For example, prohibition of dowry. There may not be anything inherently evil. Then again, taking bribe may not be anything inherently evil, but because of the social issues, they are considered, they are created as offenses. So the difference is between specific offenses and the strict liability offense. And in the present criminal justice system, we can see the statutory framework comprising of the major code, Indian Penal Code, and other minor legislations, and also the Code of Criminal Procedure, along with Evidence Act. And for a long period of time, we have identified certain problems and issues with the existing legislation. And so earlier in 1973, we made certain amendments. Then in 1993, we had a committee, Bora committee, and it observed increasing criminalization of politics and certain other kind of criminal activities rampant in the society. And in 2000, Malimat Committee, Justice V.S. Malimat Committee report identified that the number of punishments or the persons, the number of accused persons who are convicted are very less. So a shift from accusatorial system or adversarial system, to that of inquisitorial system was suggested by Justice Malimat, at least in certain areas. So the committee opined that the existing system weighed much in favor of the accused and did not adequately focus on the aspect of ensuring justice to the victims. That is, because of the lesser number of sentences. And regarding the current changes, which is required as well as which are suggested, we have to examine whether there is a shift from adversarial to inquisitorial as suggested by the earlier commissions. And after the Delhi raid case, a committee was constituted under the chairmanship of Justice Verma, which submitted its report in 2013. It also suggested very severe punishments to certain offenses, particularly offenses against sexual offenses against women and children, along with other suggestions. That committee also addressed the need for making stringent provisions and ensuring convictions. Then the earlier committee, 2017, that also proposed a draft policy on criminal justice. The Malimat committee also, that we had seen earlier, I think, the need to punish the wrongdoers strictly. That was the focus in all these recent commission reports. Particularly this Malimat committee suggested or highlighted the need for reforms in our criminal justice delivery system in a very efficient, effective manner. The increasing pressure upon the judiciary with pending cases and the obstructions caused in delivering criminal justice in an efficient manner. All these things were identified. And the failure on the part of investigation mechanism as well as justice delivery system in handling or utilizing the ICT enabled technology, as well as to deal with the inefficiency of the system to deal with complex kind of offenses, particularly on the advent of technology. So everything were noted even in the 2003 report. How to deal with cyber crimes, how to collect evidence in cyber cases, the scope and relevance of forensic science, and moreover, it highlighted the need to increase confidence in people, in public, that we have a very effective justice delivery system under our criminal law framework. Because the people are worried, individuals are worried, why these wrongdoers are left unpunished, why the number of offenses are increased, the kinds of offenses are increased, the women, the children, and other marginalized sections of the society are left unprotected. So, any reform in the criminal justice system should address these issues. Then you know the recommendations of the Burma Committee in 2013. It highlighted the need for speedy trial, stringent punishments, and particularly addressed how to handle the wrongdoers in sexual offenses. And the latest Ranbir Singh Committee, which was specifically constituted to review Indian Penal Code, Code of Criminal Procedure, and the Indian Evidence Act. And I have highlighted the comments of the convener of this Ranbir Singh Committee in the beginning itself. And on the basis of that comment, let us see, we have to analyze to what extent the dreams of this committee being realized. You know that, just for a moment, let us see to this existing penal system. How can we identify the commission of a crime? It is a fundamental principle of criminal law that the offense will be constituted only if there is mens rea along with the actus reus. The mind also should be involved. The mind of the accused should also be involved while committing the act which is prescribed as the offense. The mens rea, when it is to be established, we have to assess the standard of proof which is required to establish the guilt. Or in other words, the standard of proof which is required. And we know the terms which are used in the penal code to identify mens rea aspect: wrongful gain, wrongful loss, dishonestly, fraudulently, reason to believe. See, everything, all these expressions highlight the mental element. And this mental element, which is necessary while committing the act prohibited, that should be established, or the guilt of the accused should be established beyond the shadow of reasonable doubt. That is the principle which highlights the standard of proof required in a criminal trial. Or in other words, we can say that the accused person will be presumed innocent unless and until his guilt is proved beyond the shadow of doubt. So this is the presumption of innocence which is available to the accused, the golden shield which protects an accused till that particular moment of proving his guilt, which is not available in an inquisitorial system. One of the major cases decided by the Supreme Court, wherein we can see the exposition regarding this cardinal principle in this fashion. One of the cardinal principles which has always to be kept in view in our system of administration of justice for criminal cases is that a person arraigned as an accused is presumed to be innocent unless that presumption is rebutted by the prosecution by production of evidence as may show him to be guilty of the offense with which he is charged. And this burden is upon the prosecution. And unless it relieves itself of that burden, it is not possible for the court to establish the guilt. At the same time, there are certain offenses in which there is a statutory presumption, particularly in the case of dowry death, in the case of offenses against children, etc. So that is, in that area, we can see a shift from the basic or fundamental principle to that of inquisitorial system in certain areas. And in Kaliram, again, this cardinal principle had been reiterated in very clear terms, by which we can understand to what extent the prosecution has to discharge this utmost important responsibility. How much it is relevant, how much it is important. If the prosecution is not acting responsibly, it is not possible for the judge to punish the wrongdoer. And in other words, we have to say that, or we have to identify the failure on the part of the prosecution to effectively collect evidence. And in that count, we should recollect the findings of the earlier commissions, that the failure on the part of the investigation to effectively utilize the assistance of technology, forensic science, and other kind of developments which we witness in our day-to-day life. And in Subramaniam versus State of Tamil Nadu, you should remember that this is a case in which the offense of dowry death was under consideration. The dowry death is an offense in which there is a statutory presumption. Even in that case, statutory presumption against the accused. And even in that case, the Supreme Court observed that the fact of living together is a strong circumstance in favor of the guilt of the accused, but that by alone, in the absence of any evidence of violence on the deceased, particularly by the accused, cannot be held to be conclusive proof. Okay, and there should be some evidence to arrive at a conclusion that the husband and the husband alone was responsible therefore. So this is a case in which there is a presumption of guilt, which may be rebutted later. And Nageshwar Rao versus State of AP, here also, the responsibility of the prosecution was highlighted. Then another interesting case, Govindaswamy versus State of Kerala. Herein, a woman was pushed out of the train and rape was committed by the accused. Both the Sessions Judge High Court affirmed the conviction with respect to the offenses of rape and murder. And there were two injuries which led to the death of the victim. And the expert who conducted the postmortem deposed that the first injury was sufficient to render her in a state of dizziness and insensitiveness. But she will not become unconscious. And this alone will not result in the death. This injury will be caused only if the head is forcefully hit to backward and forward against a hard, flat surface, like the wall of the train. But this injury will not put her in total unconscious state. Then another injury, that is the injury sustained from beneath the left eye up to chin bone. And again below and on lips. There are fractures and about 13 teeth have gone severed. Okay, see, and along with this, there were severe bleeding. There was severe bleeding. And this second injury became so fatal, though injury numbers 1 and 2 together resulted in the death. From the evidence, the court assessed that injury numbers 1 and 2 and the complications thereafter led to the death of the victim. But upon a very, very simple matter, the apex court concluded that the prosecution could not establish the fact whether the appellant himself had pushed her from the train, causing injury number 2. The court observed, however, so far as injury number 2 is concerned, unless the fall from the train can be ascribed to the accused on the basis of the cogent and reliable evidence, meaning thereby that the accused had pushed the deceased out of the train, and the possibility of the deceased herself jumping out of the train is ruled out. The liability of the accused for the said injury may not necessarily fall. So, the possibility that, a mere possibility that the deceased might have jumped out of the train. But we know the greater possibility is that the accused had pushed her out because she was in a state of dizziness. Even then, the court acquitted the accused for the offense of rape. For the offense of murder. Definitely, he was convicted for the offense of rape based on scientific evidence, including DNA profile. Okay, so this is the beauty of the system which we are following. I said it is the beauty because there is every chance that the accused, if he is an innocent person, to be protected. But the criticism is that when a charge is initiated against an accused, then the media and the public would be much agitated in the offenses like Soumya murder case or Delhi rape case, the common people, the society may have a feeling that he should be punished with very severe punishments. So let us think, let us discuss which system is better. And again in Vincent versus State of Kerala, again the court emphasized the responsibility of the trial judge to bring sufficient evidence to establish the guilt of the accused beyond the shadow of reasonable doubt, even if the prosecution fails to adduce adequate and sufficient evidence. See, this position was reiterated again in State of Rajasthan versus Anil by Justice K.T. Thomas, section highlighting the importance, the scope of section 165 of the Indian Evidence Act. And we have so many legislations and so many provisions wherein liability is attributed upon the accused by adducing presumption of guilt, which is an important principle in an inquisitorial system. So in relevant situations, we have adopted relevant principles as an exception to the system of adversarial justice delivery. In POCSO section 30, presumption of culpable mental state is provided. In any prosecution for any offense under this act, that is POCSO, Protection of Children from Sexual Offenses, which requires a culpable mental state on the part of the accused, the court shall presume the existence of such mental state, but it shall be a defense for the accused to prove the fact that he had no such mental state with respect to the act charged as an offense in the prosecution. See, the nature is well prescribed in clause 2. A fact is said to be proved only when the special court believes it to exist beyond reasonable doubt, and not merely when its existence is established by a preponderance of probability. So this statement, this clause is very much relevant because in ordinary cases where a defense is raised by the accused, he is to prove the existence of the possibility of a defense only on a preponderance of probability. But here under POCSO, it is not permitted. He has to rebut the presumption against him, not by a preponderance of probability, but by the strict proof, by the principle of strict proof, that is beyond reasonable doubt. And in this context, let us see, let us evaluate the need for the existing reforms. We have seen that the entire legal framework is tried to be changed by replacing the existing codes by 3 new legislations. Even the very names, very nomenclatures being replaced. And see the position which favors, or the points or the factors which favor the proposed reforms. That is regarding, the first thing is regarding updation. The Indian Penal Code is a very old ancient legislation which came into force during British colonial rule. And it is identified as outdated, consisting of certain substantive pieces of creation of offenses which should be eliminated, like adultery, unnatural offenses. Okay. Then it is identified. Another argument which favors reforms in criminal laws. There is a failure on the part of the system to effectively utilize the developments which occur in the modern times, particularly in the process of collecting evidence, in the process of identifying modern techniques used by the culprits in the commission of offenses, and the failure on the part of a clear definition and understanding regarding cyber crimes, etc., etc. And definitely, another thing which is identified that favors reforms is the present delay which we face in the process of administration of criminal justice. The criminal justice system should be able to deliver speedy justice. That is a very important aspect. The slow pace of police investigations are identified, and that is identified again in miscarriage of justice. And the existing system is identified as not fit to provide transparency in proceedings. The need to have a speedy justice delivery system that is identified even earlier. So let us see some of the important provisions. See, not provisions, clauses in fact. In place of sections, the term clauses are used in these three new bills. Some examples which I have to highlight is the definition of the offenses in the Bharatiya Nyaya Samhita. This is the bill which intends to replace the existing Indian Penal Code. A very difficult issue as far as we, the senior persons, are concerned. See, the section numbers like 299 culpable homicide, 300 murder, then 304B dowry death, then the number of the section which provides defamation, everything. Section 84, unsoundness of mind. Then see, everything are replaced, or a real mess is created that may be an issue with respect to senior persons like me. But it is a fact that the entire structure regarding arrangement of the definition of offenses are thoroughly revised. I don't know what is the advantage of such a revision. Anyway, see, let us see another example, that is the definition given to certain offenses. Terrorism, provisions are given to deal with the offense of terrorism, corruption, mob lynching, organized crimes. You know, clause 109 provides for organized crime. So I'll read clause 109. That is very much interesting. Any continuing unlawful activity, including kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offenses, cyber crimes having severe consequences, trafficking in people, drugs, illicit goods or services and weapons, human trafficking, racket for prostitution, or ransom by the effort of groups of individuals acting in concert, singly or jointly, either as a member of an organized crime syndicate or on behalf of such syndicate by use of violence, threat of violence, intimidation, coercion, corruption, or related activities or other unlawful means to obtain direct or indirect material benefit, including a financial benefit, shall constitute organized crime. Now tell me, what is an organized crime? So many offenses which are already discussed or which are already defined separately, either in the penal code, existing penal code, or in different separate statutes, are brought under a single clause, providing for a single offense of organized crime. Then how will you analyze which are the constituent elements of organized crime? I have earlier narrated that an offense would be constituted only if the actus reus and mens rea are established beyond reasonable doubt. Okay, what is an organized crime? See, land grabbing, contract killing. What is it? Contract killing. Is it murder? Which is defined in another place in this particular bill itself. Then again, trafficking in people, drugs, illicit goods, services, weapons, everything are brought under the same umbrella as if all these acts are of a similar nature. Then again, see, how will you punish for this organized crime? When jointly committed, do we need the presence of joint liability? Or when it is committed by intimidation, threat of violence, then again corruption, when it is done under threat of violence, intimidation, coercion, corruption, how will you interpret such clauses? I feel it very much difficult. See, as a person who has interpreted the provisions in the penal code for a long period of time, and as a person who taught law relating to interpretation for a long period of time, I am not in a position to give a clear meaning and interpretation to this clause 109, which defines organized crime. Then again, we are familiar or we are aware that there are specific statutes to deal with organized crimes in different states. Then we may be familiar with Makoka, Gushkoka, which particularly deal with organized crimes, which are drafted, which are prevailing in different states. Due to the paucity of time, I am not going that much deep into the definition of organized crime. So you feel how much is it difficult to identify what is organized crime. When a provision is difficult or unable to interpret in a clear manner, then that will result in unfairness in the administration of criminal justice, because it gives freedom to the police to give a definition, to give a meaning to the expressions used under 109, and then they, according to their whims and fancies, will charge people for the commission of organized crimes. And you should be aware that the punishment is very severe under clause for the offenses under this clause. And again, the offenses relating to terrorism or terrorist act, offense of terror, clause 111. A person is said to have committed a terrorist act if he commits any act in India or in any foreign country with the intention to threaten the unity, integrity, and security of India, to intimidate the general public or a segment thereof, or to disturb public order by doing an act. How will you identify which are the acts that may result in terrorist act? Here also, see, the result would be to entrust or to leave the police with the freedom to interpret the clause and to book any person whom the police wants to arrest. And we know the difficulties which may be followed when a person is arrested under this clause. We know the history of the legislations which were intended to prevent terrorist activities. Initially, we had TADA, Terrorist and Disruptive Activities Prevention Act. Then replacing TADA, POTA came in. Then now we are having UAPA, Unlawful Activities Prevention Act. Still, we are in a dilemma without having an adequate piece of legislation and an adequate machinery or system to effectively curb terrorism. In such a situation, what is the use or what will be the result of having such a single provision which defines a terrorist act in a very improper manner, in a very general sense? Okay, I have to mention many things regarding this particular provision. And again, we have to discuss a number of factors. Then it is claimed that this new legislation, the Criminal Procedure Code, the Bharatiya Nagarik Suraksha Samhita, replacing the existing Code of Criminal Procedure, provides for a situation of zero FIR. That means this law or the proposed bill allows people to register a police complaint in any police station, regardless of the location where the crime took place. That is a good initiative. Then again, regarding ICT applications, they propose this legislation propose video recording of search and seizure operations and the facilities to use electronic evidence and forensic science during investigation. That's also an appreciable move. And another thing which should be commended upon positively is the inclusion of community service in the array of punishments. That's a very good initiative. But at the same time, the law regarding sedition clause that is replaced, and the offense has been judiciously tempered to prevent misuse, and a test of criminal intent is added. The term sedition is not used, but a general expression regarding the acts which may result in such activities. Then definitely the provisions to provide speedy justice, that's also a good initiative, and it is in line with the Supreme Court decisions in that aspect. And the provisions regarding under trials, that the police superintendent has to ensure that an application is made to the court to release under trials who have completed that much period of their maximum possible sentence. The clause 150, that needs further examination. That is, law relating to sedition, whether it is expanded or it is deleted. The new bill punishes acts endangering. As I have mentioned earlier, a general provision, a general provision is given that the acts endangering sovereignty, unity, and integrity of state are punished. Will you identify, or who will identify? Many a time, political connections or political assessment may result in the arrest of the person, so many persons. Though the provision relating to sedition was deleted from the existing code on the ground that that will result in unfair administration of justice and arbitrary arrest against persons who are politically in an opposite belief. And the major thing which we have to understand, we have to analyze is the vagueness, which is very clear in almost all the definitions and the provisions dealing with procedural aspects. It is clear, it is definite that we have borrowed some pieces of legislations, and we have borrowed so many provisions, or almost all provisions from the existing code, and wherein we have added new provisions that created a real mess. And offenses including sedition and obscenity require reconsideration. Definitely the organized crimes, terrorist activities. And another thing which I do want to highlight is the provisions regarding marital rape. Though there is a demand from various corners of the society, particularly from women activists, that marital rape should also be included in the new bill as an offense, that plea was not addressed. But at the same time, in tune with Independent Thought versus Union of India, in clause 63(6), if the husband enters or is involved in sexual intercourse with his wife, if he is below the age of 18, that would be an offense. But generally, marital rape is not included in the code, in the bill, as an offense. And again, look into clause 78. The terminology used is modesty. Offenses insulting the modesty of a woman. And again, the expression used, privacy of woman. An offense, an act which may affect the privacy of woman, would be considered as an offense which insults the modesty of a woman. See, all these terms are ambiguous. Insulting, what does it mean? Modesty, what does it mean? Then privacy of a woman, what does it mean? So I am very particular that very clear meaning should be given to the terms which are used in a statute which is penal in nature, because based on that meaning, based on that definition, the accused persons would be brought before the court. So it is not fair, it is not just to leave the matter of interpretation into the hands of the executive. And again, see, we should address the issue of torture which the accused persons happen to suffer during investigation. Then again, another controversy is with respect to the penalty, the punishment given to mob lynching. Let us just see clause 101(2). Clause 101(2) that deals with the punishment for mob lynching. when a group of 5 or more persons acting in concert commits murder on the ground of race, caste, or community, sex, place of birth, language, personal belief, or any other ground, each member of such group shall be punished with death or with imprisonment for life or etc. Okay, now when the system has to give a punishment of death to a mob who are the members of which are involved in causing the death or causing murder, you know the definition for murder, then how can we give capital punishment to all these persons unless we are able to establish the guilt of each individual offender towards commission of murder? So there is something against the very spirit of this definition or this provision which gives death penalty to the crowd, to a crowd. Even when the 2020 Commission claims that they are about to make new legislations replacing the existing three for the purpose of removing or leaving aside all the outdated laws. From a close reading of the three bills, we can see that almost all the provisions in the erstwhile Victorian legislations, which enshrines Victorian morality, social morality, religious principles, have been included in the new pieces of legislations. And there is a criticism. Along with it, I do wish to highlight the criticism raised against the committee also. Their reports, their deliberations, their suggestions, everything are behind public access. So I just casually mentioned such a criticism. And the strategic power as such, the political executive has consistently sought to wield criminal law as a preemptive tool, and the proliferation of this approach to criminal law raises legitimate concerns. So that was also a criticism leveled against. Then regarding the provisions regarding police custody, so it's expanded from 15 days to over 60 or 90, depending on the offense. Then regarding international practices, to what extent these international practices were appreciated in the present code. Another aspect which I do want to highlight is regarding rights of the accused. It is very relevant that in the existing system, the right of the accused to be present during trial is well appreciated. And if the accused is absconded, then the trial would not be initiated. But even while ensuring such a right to the accused to be present during trial, examination, cross-examination, let us see clause 335. If the accused has absconded, that is available in Bharatiya Nagarik Suraksha Sanhita, clause 335. Accordingly, even if the accused is found absconded, the court will initiate trial in the absence of the accused person. Then 357. Again, that should be identified as an unfair provision. When the accused does not understand proceedings of the trial, the judge can decide whether to proceed with the procedure. Then again, another clause 359 regarding compounding of offenses, various kinds of offenses that may vary from assault, theft to defamation, then causing grievous hurt. So many offenses without any rationale. Then we have to again look into the veracity of these changes, the proposed changes. To what extent the claims are being justly addressed, that substantive provisions are being clearly provided without much lacuna in interpretation, whether offenses are being clearly defined, the actus reus part as well as the mens rea part. Are the principles of equality, equitability, and public trust complied with? Whether the aspects of security of the state and the freedom of individual are well balanced. And regarding the effectiveness of the reforms visualized. To what extent the interests of the vulnerable groups of the society are addressed with. Okay, these all are the ideas or principles which we have to keep in mind while going through the proposed bills. I have started from a premise that we have a system of administration of criminal justice which comprises of customary practices, precedents, common law principles, along with well-drafted codes, though they are very ancient. While we are attempting to reform such existing legislative framework which are well addressed in or well founded in various premises, that should be done very carefully. The reformation or revisiting of the existing pieces of legislation should be done meticulously, carefully, so as to protect the stakeholders like society, accused, as well as the victims. And also, it provides room for the system of investigation and the system of judiciary to effectively deal with the functions for the effective administration of criminal justice. And I think at this point, it's better to stop my, or to put an end to my oration. It's simply a look into the deep sea. And it is for you to initiate further discussion. And I think it is the appropriate time for discussion. Okay, you may put your questions directly.
Teacher, there are a couple
Yes.
of questions in the chat box. May I read it?
Okay. Oh, so many questions.
Yes, yes.
Ritu has identified difficult to define. So that is an aspect which I have highlighted, simply citing certain examples. And it is there in almost all the sections, or not sections, clauses. Clauses are the terms used in place of sections. Okay, then again, I didn't get that what was in the
No, ma'am,
temple.
I was just commenting
yes.
on something which you said, like some assessments which you made was so excellent. So I was just commenting on it. I didn't posted any question.
Yes. Okay. Then, ma'am, I have question regarding the new bills. Why there was a need to change the whole statute, rearranging the order that will hamper with students who are in preparation of the law exams, uh, and the government doesn't had the second thoughts of just adding amendments to the same existing laws. See, the very same anguish was highlighted by me also. See, I thought it was the problem with my age and familiarity, but it's quite interesting that everybody feels the same difficulty. It's quite true that, see, I just simply mentioned it in a simple way, but it is true that why such a need, or what was the need for such a creation of mass? I couldn't get why. Maybe some reasons, I don't know. Then whether compensation to the victims of crime in India is the vanishing point of criminal jurisprudence. I don't think so, because the protection of victims, that is a very important aspect as far as criminal justice administration system is concerned. We have to look into the interests of the society, the individuals of the society, particularly the accused as well. And one of the most important aspects is to satisfy the grievances of the victim. And in that count, paying compensation to the victim is a very good move. But paying compensation, or ensuring compensation by the convict, that will not create any burden upon the state or upon the ordinary taxpayers. But at the very outset of initiating a complaint or or lodging an FIR, under the compensation scheme envisaged by the Code of Criminal Procedure and also the new bill, at the initial stage itself, the victim is entitled for compensation. There may be a criticism against this procedure, but we have to think of the state of affairs of the victims, particularly the victims of sexual harassment, rape, and that kind of offenses. The women, the children under the POCSO Act, and definitely the marginalized sections. For example, the victims under SC/ST Atrocities Prevention Act. So I don't think that, as commended by you, it is the vanishing point of criminal jurisprudence, but it is the civilized state of affairs which we have to appreciate in both the counts, when the convict is to pay compensation as well as the state is to pay compensation. So, you know, a particular case in which the victim of rape was directed to pay compensation even under writ jurisdiction. So the legal system is well aware of the needs of victims. It's not possible, not at all possible, to bring the victims to the initial position, to restore to the original position. But we are extending a helping hand to the victims so that they may be rehabilitated, they may be brought to the initial stage as if they haven't been victimized. Okay. You may have a difference of opinion, but this is my feeling. But it is based on legal premises. Okay. Then, so new crimes have been recognized by the bill. It could have been done by amendment itself. There was no need to bring new bills. Also, it will hamper students who are preparing for exams, and also it will disturb litigation system in the sense of example. Sense, for example, a case involves a unlawful assembly and common intention. Now, advocates had to do research involving new sections, and most of times case involves many aspects, and hence research will become difficult instead of reducing burden. It will add burden and makes system time consuming. That is relevant. That is a good comment. And see, the illustrative provisions which I have mentioned, so many aspects which were not connected at all, which were not of the same species, brought under a particular definition. Now there are lakhs of cases already pending in the courts. So if these new laws came into force, then what will happen to the case filed before? See, those cases should be dealt with under the laws which are prevalent at that time, and new cases will be considered under the new laws if they come into force. Okay, then with respect to sedition, government claims it has been repealed. So it has been repealed as the claim. But certain acts which in fact result in seditious, okay, that I have cited the relevant clause and the definition given. Yes, you are correct. In my opinion, it has been made more stringent because earlier sedition was against the ruling government only, but now in bare text it says disaffection against India, hence widening its scope. Yes, there is very much chances. There are chances for arbitrary exercise under this provision. Then old wine with more and more intoxication in new bottle. I doubt whether more with more and more intoxication, and in what sense you used the term, in practical aspects or in vibrant nature of revisiting the earlier sections, or in the sense that it makes the system ineffective in an intoxicant state. I don't know. Okay, then, however, the government should be praised to bring up the new idea in the sense of progressive jurisprudence. Definitely, I do appreciate the that sense of the government or that intention of the government, but the result which came out of exercising that intention, I am doubtful about it. But still, there has to be some alternatives instead of making the whole law repealed, which senior most advocates and judges have by-hearted their whole life. That's also correct. But if that is the only issue with regard to the amendments, I may not raise such criticism. But the entire aspects like framing up of sections, creating offences, providing procedures, in all these aspects, we cannot appreciate new bills. Okay. How can we protect our women's privacy, especially from technology facilitated sexual harassment? Nothing is mentioned. Certain earlier provisions were redrafted and put under different clauses. Only that much is included. And we have to think of a legal framework, what or how and by which means can we protect the technology facilitated harassment against women. So that's an issue which remains unanswerable, I think. Okay. Okay, thank you very much. Almost.
Ma'am, I have a question.
Yes.
Ma'am, first of all, I really appreciate the effort you have taken in letting us know. Like in the initial part, you told that faculties like you, it's very difficult
Pardon
when
me?
this. Am I audible to you, ma'am?
Pardon me?
Am I audible to you?
You're audible, but feeble.
Okay. Okay. Earlier, in the beginning of the session, you told that people like you find it difficult when these changes appears for criminal laws, but it is still faculties like you who are telling us or informing us or letting us know the changes, for which I really appreciate you. My question is this: that you told that like when the new offense occurs, the punishment will be taken based on the new offense. New criminal law. So my question is, after this amendment becomes an act, can the lawyers in court cite the old judgments based on IPC in court? My question is, as a precedent, can we cite the old IPC's judgment in court when the new laws come?
Sure. They can cite the earlier decisions, earlier precedents, because see, almost all the earlier offenses are now available with the new bills also. And in that count, earlier precedents can be used. And again, if it is a new offense, the terms which are used, say for example, obscenity, or say for example, acts endangering the security of the state. In so many earlier cases, see, these expressions were expanded and interpreted. Okay. Then again, modesty of a woman, insulting the modesty of a woman. See, the expression modesty of a woman has been expanded and interpreted in so many earlier cases, not only in India, but in foreign jurisdictions also. So we can adopt those precedents whenever and wherever they are relevant. Okay.
Thank you, ma'am. Thank you.
Okay, then thank you all.